colleague, Mr. Masharia, can mop up. We had gotten another indication, my lord, that we have the whole day. That's the last direction you gave before this one. So that's why your words, my lord. I'm sure the transcript will come out with those words.
That is, we speak as Africans.
Let me do the best I can in view of the new direction, because that has made me now to change my approach. Which can
Certainly, Mr. Ongoya, you didn't expect that we have the whole day. We had given directions on time,
yes,
and on your own authority of Mr. Kibe, he said you would want 2 hours. And we have agreed to that. So let's stick to the petitioner's side having 2 hours.
Let me give it my best. We'll deal with the eventualities. Allow me then just to refer you to a few things. On your ruling of 16th October 2024, at paragraph 78, you observed, and I quote, "In sum, therefore, in determining whether a matter discloses a prima facie case, a court must look at the case as a whole. It must weigh, albeit preliminarily, the pleadings, the factual basis, the respective parties' positions, the remedies sought, and the law. In so doing, a court must be guided by Article 22, Clause 1, and Article 258, Clause 1 of the Constitution, which provisions are on the right to institute court proceedings whenever a right or fundamental freedom in the Bill of Rights has been denied, violated or infringed, or is threatened, or when the Constitution has been contravened or is threatened with the contravention." Then you at paragraph 79, you observe, "Applying the above in this matter," petition 522 that is before you now, without much ado, we are satisfied that the consolidated petitions raise constitutional issues that require further judicial consideration. You made a finding that the case has inherent merit. You could see it without much ado. At paragraph 93 of that ruling of 16th of October, you observed that we have no doubt in our mind, your mind was clear, my lords, that this matter raises issues of immense public interest. A matter that raises issues of immense public interest, we argue, is a matter that is infused with inherent merit. When you consider the ruling of your brother, Justice Chacha Mwita, at page 9, paragraph 3, in petition number 550, which is now before you, the judge observes, and I quote, "There is further argument that constitutional imperatives on public participation were not complied with. The petitioner has given an example of Keio South constituency to demonstrate this fact. According to the public participation results for that constituency, the total number of people who participated is given as 43. Those who are in support are given as 70. Out of 43 participants in a public participation event to remove DP Gachagua, out of 43, 70 approved." Well, that's the case before you. This is how we have treated His Excellency regarding Gachagua, my client. Those who did not support were 3. They also got those who do not support. Having gotten 70 out of 43, there has some residue of 3 not to support. The percentage of those who support was 162.79%. We used to distinguish law and mathematics by saying that mathematics gives us instruments of mathematical precision. I don't know what the National Assembly will do with this mathematics, but this is curious mathematics. The judge then observes, it is implausible that an attendance of 43 people will produce 70 people in support and 3 in opposition. I submit that there was no remedial measure to this blatant failure by the Senate. There was no remedial measure. This poison has worked with this dispute throughout the process up to the time we come here. I'm making out a case that this case has inherent merit by these findings. At page 11, the judge referred this matter to the Chief Justice to empanel a bench on finding that the issues raised in this petition were immense. Again, that speaks to the inherent merit. When you look at the ruling of Justice L.N. Mugambi of 11th October 2024, all the way from paragraph 38 to paragraph 42, the judge highlights the matters of grave significance that this petition raises as a precondition to referring this matter to the Chief Justice. I submit that this speaks to the inherent merit of this case. And finally, at least for my part, when you look at the order from Kerogoya in petition number E15 of 2024, which is before you, at order number 3, the judge observed that the matters raised in the petition being of great national importance and urgency. He then referred the file to the Chief Justice. And I have 2 observations to make here. The finding that the matter was of great national importance and urgency speaks to the inherent merit of this case. If you look at order number 5 of the order of your brother Justice Mwongo, he gave the conservatory order because of the finding in paragraph 3, in order 3. He says, in light of the nature of the matters raised as noted in order 3, a conservatory order be issued. I want to submit to the nature of those matters has never changed. For you to vacate this order, you must convince yourselves, convince us, and convince the entire Republic of Kenya that the nature of these matters has changed. The matter has remained as it was on 18th of October 2024, which was the basis for the grant of conservatory orders. I therefore submit as follows: that because this bench, Justice Mugambi, Justice Mwita, and Justice Mwongo have, in the various rulings above, already found that this matter has inherent merit, it is not open to the respondents in their application for setting aside to invite this very court to revisit that matter and reach a contrary finding in the face of the principle of res judicata that you considered and applied on 16th of this month. I also submit that because the 4 benches I have alluded to have consistently found that this court has jurisdiction, it is not open to the respondents to argue that this court has no jurisdiction and invite this court to enter a contrary view without violating the principle of res judicata that you used against the petitioners on 16th of October. I trust that my learned colleague, Mr. Macharia, has taken note of the time and therefore he is able to compress arguments so that we pave way to the other petitioners. I urge that you grant the conservatory orders in petition number 565 of 2024 and in petition number 15 of 2024 at Kerogoya to preserve the subject matter and to give these parties a chance to ventilate themselves on the merits in the main petition. Over to Mr. Macharia.
If it pleases your ladyship and my lord, I will speak to 3 issues.